Hello, hello, everybody. Welcome back. Thank you very much for being here. Glad to be with you tonight. Boy, has it been just a crazy 24 hours here in the United States of America. This last 24 hours has been nuts. Um, yeah, I'm hoping that we can all start waking up and deciding that we can get along. That's what I really hope. You know who apparently couldn't get along? Oh man, that was a professional segue. Mickey Stines couldn't get along, apparently, with Letcher County District Judge Kevin Mullins. As you guys know, we've been following this one for a while. On, what was it, September 19th of 2024, Mickey Stines walked into Judge Mullins' chambers and fired 9 shots in his direction, killing him. And we've been trying to figure out why ever since. Now, in a normal trial, kind of motive really doesn't matter. But in this one, it feels like that's the main question. Why did Mickey Stines go in and shoot Judge Kevin Mullins? Now, what has happened yesterday was a new document was released from the court. I am now on the list of people who received these things, so I don't even have to ask for them anymore. It's pretty great. But we've got a couple documents that we're going to go over today. Do I sound maybe a little distracted? I kind of feel a little distracted. Right before I came on, I learned from some old friends that a classmate of ours passed away. Not sure how. And yeah, nobody seems to, at least that I know, seems to have been in touch with him. So I'm a little distracted. These kinds of things affect us all, right? We're all affected by death, and I think maybe as a nation we're all a little affected right now. Depends on your point of view, I suppose, but I think we're all probably feeling it a little bit. And then got a classmate that passed away, and I don't remember him, but I'm very sorry for his family. Really sucks. What are you guys saying over here? Let's see. Robin says that you were patiently waiting for us to start. Yeah, I was a couple of minutes late, Robin. I am so sorry. The hair is definitely herring. Last night I decided on Josh's show on Courtroom Confidential that I would leave it out of a controlling springy device, and it did not go well for me. Kathy says, I wish we could all get along. Yeah. We can all, and you know what, Mooney? We do get along here, don't we? Thanks to you and Autumn and Robin. Thanks for helping us get along. Speaking of Autumn, not fully here tonight, but wanted to drop in. Thanks, Autumn. Appreciate that. All right. I think that's about it. Thank you all for joining me. That's pretty fun. Okay. Gavin, why are you burying the lead? I think what I'm going to do here is this is a document that was released on the 3rd, but we're going to have to get into this document in order to understand the document that came in yesterday. And by the way, sorry, I keep going back and forth. Did you guys watch Courtroom Confidential last night? I was talking with Josh about how I thought that there was a very good argument that the Bartleys brought up in this case to dismiss the grand jury indictment, but that I thought that they weren't going to dismiss the grand jury indictment. The grand jury saw a video of Mickey Stines shooting Kevin Mullins. And one of the things that he said that struck me in part of our conversation was that defense attorneys are supposed to work to win. That is their job. Their job is to win an acquittal for their client, a not guilty for their client. A prosecutor Their job is to seek justice, not to seek the win, but they often do seek the win because it's human nature. It's not, I'm not like casting shade on any of these people. I would behave the same way. You would behave the same way with a very narrow, I guess, latitude between us. You know, we all would basically behave the same because it's human nature. But I do think that the prosecution did a little shenanigans during the grand jury. I just don't think it's going to matter much. But anyway, I really liked his input on that, his insight. We're going to have Josh on here on the channel, hopefully sometime soon. I never want to like impose on my friends, you know, and you know, like Joseph told me, he's like, no, it's never an imposition. Give me a call, whatever. Yeah, okay. I don't want to impose though. And same thing with Josh. You know, he's busy. He's got a channel. He's a working lawyer. It's tough, but we're gonna have him on here soon, I hope. All right. So back on the third, this was the defense's response to the Commonwealth's request for a second mental health examination. You'll remember that Mickey Stines was given an examination it was court ordered. That examination has been sealed. We haven't seen it yet, not to my knowledge, not to my memory. I think it's still sealed. And all we need to know here is the Commonwealth is like, we want a second opinion. So this is what his attorneys, Jeremy and Carrie Bartley, wrote the court. They said, comes now the defendant, Sean Mickey Stines, by and through the undersigned counsel, and states its opposition to the Commonwealth's request for a second examination. For grounds, defendant states as follows. Defendant filed a notice of his intent to introduce mental health evidence on February 24th. The Commonwealth then filed the Commonwealth's motion for examination on March 10th, 2025. The Commonwealth identified its request as one pursuant to these statutes, to this statute, which allows the Commonwealth to request and obtain a mental health examination. I think they put that emphasis in there themselves. The defendant has already gone this psychiatric evaluation conducted by the Kentucky Correctional Psychiatric Center, which is a state facility authorized under the statutes ordered by the Commonwealth. This evaluation was conducted in accordance with the statutory framework that ensures fairness and equal access to state resources for both the defense and the prosecution. The Commonwealth's request for a second evaluation fails to demonstrate a compelling need that would justify subjecting the defendant to an additional evaluation. Kentucky law emphasizes the importance of procedural safeguards to ensure fairness and impartiality in such cases. To mandate the defendant to once again be subjected to an invasive examination is without statutory basis. The Commonwealth is free to enlist an expert to review the prior examination and espouse a contrasting view. Mr. Stines has already submitted to the same testing that is used in capital trials by the Commonwealth throughout the Commonwealth. The Commonwealth, we're talking about the state of Kentucky here. I heard that in the South, what they do is they put the emphasis on the first syllable of things where it's not supposed to be there. So it's Kentucky, not Kentucky. But what do I know? The Commonwealth has the existing KCPC report, medical records, and other discovery already available for its expert to base his or her opinion. In this case, the initial KCPC evaluation is sufficient, and there is no evidence to suggest that a second evaluation is warranted other than the desire for a second opinion. Allowing the Commonwealth this second evaluation will unnecessarily prejudice the defendant. I mean, I'm with them on their argument. And as a professional waffler, I am convinced every time I read one of these arguments, doesn't matter who it comes from. I think they're all good arguments. However, how does this prejudice the defendant? I don't know. Let's go on. that must be the rules of criminal procedures, provides the Commonwealth a mental health examination, not multiple examinations based on their feelings on the one rendered. The Commonwealth is not entitled to more favorable status under the criminal procedure than the defense. In Benjamin v. Commonwealth, the court held that a defendant is not entitled to an additional evaluation because the initial evaluation was unfavorable to their defense. The same standard should be used for the prosecution. They should not be allowed to obtain another evaluation simply because the initial KCPC evaluation is unfavorable to their case. Not only would this result create an uneven playing field, but it would create an unreasonable delay and impediment to the defendant's right to a speedy trial. I think it's funny that, and this isn't a criticism, this is just like it's not a criticism of the Bartleys, it's a general criticism, okay? The criticism is that everybody wants a speedy trial unless they don't. Ooh, this is my right. Let's do the speedy trial. But they don't care about the speedy trial. It's been a year. We're barely even into this thing, right? Okay. So under the criminal procedures, the defendant has complied with the Commonwealth's request for an examination by the expert they chose, and that was KCPC. This court's order was based on that request. There's no basis for mandating that defendant be compelled to again waive his right to remain silent. There's no statutory basis for him to be compelled. Dr. Eric Drogan was identified early as the defense expert and even insisted that he participate in the KCPC evaluation. Without question, the KCPC examiner would be testifying in rebuttal to Dr. Drogan had his opinion been different. The KCPC criminal responsibility examination was performed at the request of the Commonwealth, not as the court's expert, as there is no basis for the same without the issue of competency having been raised. And they did not raise the issue of competency. I see what they did here. Okay, so no basis for a court expert if they didn't raise the issue of competency. Thus, they did not raise the issue of competency. Smart. Oh my goodness, do I love good lawyering? That's smart. So they specifically are like, yeah, we don't care about competency because they didn't want the expert. Okay, I'm catching up. It takes me a while, but I'm catching up. Wherefore, the defendant respectfully requests that this honorable court deny the Commonwealth's request for a second evaluation of Mr. Stines, limit the Commonwealth's rebuttal expert to reviewing the existing KCPC report and underlying materials. Alternatively, allow defendant to further support its opposition with reference to the sealed examination. Yeah, they want to unseal it. Respectfully submitted, the Bartleys. Okay, so that's where we are here. Okay, that is the motion at hand. That is why this next one came out. This is, let me bring it up so it'll actually, so we can see it. This is the Commonwealth's response. Before we get to it, though, how about we just check in to see what you guys are saying over here? Susan says, all the lawyers I know are very competitive no matter what side they're on. Yeah, I think you're right. I told Josh last night, I have a friend who's an attorney who has, I mean, he's almost old enough to be my dad. He's been an attorney for a long, long time. And I can't remember the context in which we were talking, but he said, "Hey Gavin, do you play basketball?" And I was like, "Well, I did, when I was young." "Okay, did you like to win?" "Yeah." "Lawyers are the exact same way. It's a game. They like to win." I'm like, okay. Yeah. So it's the way it is, I guess. Right? All right. Let's see. Where am I? Go back over here. Here we go. All right. So the Commonwealth responded to the defendant's opposition for mental health evaluation. Comes the Commonwealth. by and through the undersigned Assistant Attorney General and Commonwealth's Attorney for the 27th Judicial District in response to the defendant's response in opposition to Commonwealth's request for second mental health examination. All right. All this we're going to read it because it's not long. This is like a 4-page document. On February 27th, with the filing of the defendant's notice pursuant to RCR 807, the defendant advised the Commonwealth and this court of his intention to raise a defense of insanity at the time of the crime and to present expert evidence relating to a mental disease or defect or mental condition bearing on the case. Sorry, give me a second.
Sorry, I don't understand.
Oh, no, I didn't say Siri, give me a second. I said, sorry, give me a second. Okay. With the filing of the notice pursuant to RCR 807, the Commonwealth was provided with 10 days to file a motion for the defendant to be examined in response to the defendant's notice pursuant to RCR 807 in accordance with RCR 807 1B and 2B. The Commonwealth filed a motion for evaluation at the Kentucky Correctional Psychiatric Center on March 10th. The court ordered the evaluation. The defendant's expert was permitted to participate in the evaluation, which has now been completed. While the defendant asserts that RCR 807 provides the Commonwealth a single mental evaluation, nowhere in RCR 807 is that restriction stated explicitly or otherwise. I'm sorry, it tickles me because when we go back over here, typically when you add emphasis to something, you will note emphasis added, and I recognize that that was conspicuously missing. So their whole argument of you get one shot at this, the Commonwealth is going, what now? No, it doesn't say that. RCR 807 does not have that restriction. It's not explicit, it's not implicit. Okay. The defendant, in advising the Commonwealth and the court of his intention to raise a defense of insanity at the time of the crime and to present expert evidence relating to a mental disease or defect or mental condition bearing on the issue of guilt and punishment, initiated this inquiry. The defendant raised this issue and cannot now bar the Commonwealth from conducting its own independent evaluation of the defendant. Well, that must mean that the KCPC examination was favorable to the defense, right? That examination, which we would all love to read, man, boy, would I love to read it. It's not in any document that I have. It did not accidentally get leaked to the press or anything. Okay. The defendant's reliance on Benjamin v. Commonwealth is misplaced. In Benjamin, both a competency and criminal responsibility evaluation were completed for Benjamin at a state facility. Benjamin requested state funding to hire an additional expert, and that request was denied by the trial court. The Supreme Court of Kentucky, when reviewing for abuse of discretion, ultimately found there was no due process violation resulting from the trial court's denial of Benjamin's request for funding to hire an additional expert. The court, in conducting a balancing test, relied on the fact that an evaluation had already been completed at a state facility in Benjamin, other than on the first day of trial, failed to state with specificity the need for an additional expert. The Supreme Court ultimately concluded that due process does not require funding for a second mental health evaluation under Chapter 31. Here, in contrast to Benjamin, no request has been submitted to this court for funds. Moreover, the Commonwealth's request for an additional evaluation was made far in advance of trial. Consequently, Benjamin is markedly different and provides no authority binding or persuasive to this court. Okay, see, I was so convinced by the first argument, and now I'm falling by. Again, I'm a waffler, right? It's what I do. Further, 8073 specifically negates the defendant's argument that he should not be required to submit to an additional evaluation and be compelled to waive his right to remain silent. Under 8073, it says inadmissibility of a defendant's statements made in course of examination under rules 806, 8071, 8072. No statement made by a defendant in the course of any examination conducted under these rules, whether conducted with or without the defendant's consent, no testimony by an expert based on any such statement, and no other fruits of any such statement may be admitted into evidence against the defendant in any criminal proceeding except on an issue regarding mental condition on which the defendant A has introduced evidence of incompetency or incapacity to stand trial under Rule 806, B has introduced evidence requiring notice under Rule 807(1)A, or C has introduced evidence requiring notice under Rule 807(2)A. So basically they're saying no statement made by the defendant under these rules, no testimony by any expert based on any such statement, and no other fruits of any such statement may be admitted except and on issue regarding mental condition. Basically, they're saying, hey, if this person is in a mental condition and to say that he, stole the Statue of Liberty, that can't be held against him, right? Like if the only thing that can be used is mental condition. Okay, Rule 8073 directly addresses when statements made by a defendant during a Rule 807 evaluation may be admitted into evidence against the defendant. 3 expressly prohibits the use of statements made by the defendant during an examination unless the defendant himself has introduced evidence of incompetency, evidence of insanity at the time of the crime, or evidence relating to a mental disease or defect or mental condition bearing on the issue of guilt or punishment, which he would in this case, right? By asserting the defense of mental illness or insanity and claiming he lacks criminal responsibility for shooting and killing Letcher County District Court Judge Kevin Mullins, the defendant himself initiated inquiry into his mental health. Okay. I mean, it's this compelling argument. The Commonwealth has a right to rebut this defense as recognized by the Supreme Court of Kentucky in Bishop v. Caudill. In Caudill, the court held the issue of whether a defendant is criminally responsible for the offense with which he is charged is a fact for the jury to decide. Accordingly, the Commonwealth must have the right to rebut this position, a right which necessarily includes obtaining its own independent examination of the defendant. Since the results of the Commonwealth's examination are admissible only to rebut the mental health evidence introduced by the defense, appellant can preclude introduction of the Commonwealth's evidence by declining to assert such evidence on his own behalf. Emphasis added, because it was, actually in there. The court recognized a right for the Commonwealth to rebut this defense and a right to obtain an independent examination of the defendant. Accordingly, Commonwealth is entitled to obtain a private expert to conduct an independent evaluation of the defendant as to criminal responsibility. Practically, to exercise the Commonwealth's right to rebuttal, the Commonwealth must be provided with the opportunity to present expert testimony about the defendant's mental health. If the defendant intends to use the evaluator from KCPC as a defense expert, that same witness cannot also serve as the Commonwealth's expert. Thus, the Commonwealth should be entitled to seek its own expert. Wherefore, blah, 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 respectfully request, blah, 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 blah. I don't know. What do you guys think? So, Mickey Stines. See, here's your problem, Mickey Stines. You done gone shot up a judge on camera, and now you're trying to get out of it. Now, I am all for not holding somebody criminally responsible for something that he or she is not criminally responsible for because of some mental break or insanity. I'm all for it, but I don't know if you're going to convince a jury of it. I just don't think you're going to convince a jury of it. I don't know. What do you guys think? Let's see what you're saying on over here. I don't think you guys are all that talkative today. Let's see. Not very talkative, but here's Mooney. Mooney says, so the state requested that particular doctor. I can't tell if the state requested that doctor or not. They requested the facility. So I'm not sure. I'm not sure. Kathy says, hey, to the fish tank, thanks to everyone who showed up last night on Courtroom Confidential. I love the Gavin Josh collab, and y'all were so kind in the chat. You know what, Kathy? That is so nice of you to say. Thank you for coming and telling us. Thanks for coming and telling us that. We do pride ourselves on having a very friendly live chat. In the nation, in the United Nations of live chats, all across the fruited YouTube plains, from sea across the ocean, the isles of the sea, however you want to say it, we are Canada over here. We're just happy, kind people. And it's thanks so much to the viewers, but also to our moderators that keep everything super chill. So I'm glad you're here. Susan says, Gavin, I love it when lawyers argue case law that is on point. There's something about logical argument like this that makes me smile. Yes, I know I'm a nerd. Hey, I nerd out about it too. I was telling Josh yesterday, this kind of stuff where you're just watching lawyers kind of battle it out rhetorically, right? It's like a tennis match. And I'm just appreciative of the process. If I were to go to watch tennis, I don't care necessarily who wins. I've only gone to watch a couple times, but I'm never invested in who wins, but I really do enjoy the game. And I'm that same way with baseball. I grew up in a baseball family. Oh my goodness, the amount of baseball that we consumed growing up. So many games that we went to. In fact, I'm going to get sidetracked, but as a grown up, I honestly don't care about who wins or loses a baseball game, but I do love going to the field. I really enjoy that. But that reminds me, this is a tangent. 4 years ago today, I saw in my Facebook memories, Kimberly and I, my sister and brother-in-law who live pretty near to us, and my parents who flew out for that purpose went to Cooperstown to the Baseball Hall of Fame, and basically fulfilled one of my dad's childhood dreams. And it was really funny. He was so sweet that entire time, wanting to make sure that it wasn't just about him, and that we were all having a good time too. Of course, we were all having a good time just because he was having a good time. He loves baseball that much. And anyway, that was a terrific weekend to spend in Cooperstown, to see the Baseball Hall of Fame, to see the part that I liked the most was the art gallery, which was just amazing. Anyway, baseball tangent. Love baseball. Love baseball. Let's see. If he has the trial in Letcher, it may be woke. I don't understand the question. I'm not sure. Mooney says, I watch my Nats every night. I'm going to Saturday's game. Well, good on you. My dad's Dodgers were in town recently to play the Buccos, and Buccos kind of destroyed my dad's Dodgers. Let me tell you a story about my dad, okay? I don't know why I do this. You guys are like, I don't care, Gavin. But, oh no, Robin's cool. Robin says you do like my side stories. Okay. My dad, has always been just a very good, sweet person. He's a very good friend especially to those who don't have them. He's always been a very, very good person. I don't know why I started out that way. I just wanted to say it, right? It's really easy to admire somebody like my dad. Really easy to try to emulate them in your life. He's awesome. But as I understand it, because I wasn't there, because it was many, many years before I was born, uh, my my dad's dad died. Dad was 7 years old and about to turn 8. Um, of course, that broke the family. In fact, when I was thinking about this whole Charlie Kirk thing, a totally different thing. My grandpa was not assassinated. He died in an accident. Um, but the thing that is the same is that there are two little children that will grow up without a father. And, uh, and my grandma remarried. Grand, the grandpa that I knew, he's technically my step grandpa. He's a good guy, right? Um, but anyway, my dad took up, well, he had already been doing Little League at that point, or Pony League, whatever, T-ball or whatever it was. But the story that he tells is that he would take out his frustrations pitching a ball against the brick house. Just throw the ball, throw the ball, throw the ball. And I mean, they moved a couple of different places. He grew up, but by the time he got to high school, he had himself a very good pitching arm. And anyway, baseball, he says, saved his life from being a sad little boy to being a boy who remembered what it was like to be happy again. So baseball was a big piece of our life. I don't watch everything. I don't go. I don't watch everything on TV, but when I go to the ballpark, it's some of the happiest memories I have. Uh, all right, let's see what we have here. LV MPCA says, Gavin, it only takes one juror to believe this, and you have a hung jury. So not surprised that this is what the attorneys go for. Oh, that they're arguing so vigorously, right? This is the center of the case. So absolutely, you're absolutely right. Um, Phoenix Rising. I'm late. I tuned into yesterday's stream by accident. I was confused why Gavin didn't know the details yet. Yeah, that was, oh, guys, that was a sad, sad day for everybody. Uh, I think, what's it? Okay, so Josh Shapiro, an assassination attempt was done on Josh Shapiro. They tried to burn down the governor's mansion. There was, I think it's a stretch to say two attempts on President Trump, but we could argue that there were two attempts on President Trump. Um, who else am I thinking about? Why am I blanking? Just it just seems like we're in a very dark place right now as a country that we can't get along. And I've talked about this on this channel about like people that I go to church with who won't go and visit other people at church just to check on them, just see how they're doing because their politics are different and they just can't get past that. I don't know what we're going to do. I don't know what we're going to do. Robin says, "Oh man, not me over here sniffling." Yeah, yeah. Baseball saved Dad's life. His second savior was my mom, who, I mean, my mom deserves the credit, but also my dad didn't have the relationship with his stepdad that he would have had with his own father, right? Because his dad was very much like him, according to everybody. Of course, people tend to be deified a little bit or angelified a little bit after they pass, but I've never heard anybody say a bad thing about my grandpa. Everybody has always only ever told me that I was so blessed to have him as my grandpa, though I never knew him. But Dad didn't have a good relationship with his stepdad. Not the same that he would have had with his own dad, I guess is how I would say it. But my mom's dad, even when mom and dad were just teenagers, my mom's dad was a father figure that took him under his wing and really loved him. Pretty great. Let's see. Oh yeah, the state reps in Minnesota, Paul Pelosi. Yeah. Oh my goodness. Yeah, I forgot about Paul Pelosi. Crying out loud. I just, growing up in so I was born in the 70s. Uh, the last assassination, well, one of the assassinations that was talked about a lot growing up, obviously, was Martin Luther King Jr. And I really hoped that we were past that as a nation. I really did. Just, yeah. Yeah, state reps. Oh, yeah. Yes. Uh, Mrs. Kelly, crying out loud. Yeah, we just have a lot of problems right now, man. A lot of problems. And I wonder how culture it is. If we can bring back in this case, right? Now, Mickey Stines is saying that he was criminally insane when he did it, right? He didn't have the culpability of doing it. I was going to say Ronald Reagan, there was an attempted assassination on Ronald Reagan. I remember that. I do remember that. But there's this idea that people think that it's okay to full on Wild West settle minor beeves with iron. And I did see today that they announced that they had found the weapon. It was a bolt action long gun. I kind of felt like that was going to be the case. One shot, one hit, kind of, yeah. Yeah, Robin. Yeah, the Minnesota congresswoman and her husband. Yeah, it's just a sad time for us, and um, I hope that we can come to ourselves. You know, I don't mean to like leave it on that like note. This has been a sad kind of a melancholy. This has been a melancholy stream. Crying out loud! We need. You know what we need? We need. Yes. Okay, that's what we needed. We just need to get a little transition music and get back into Happysville. Um, oh, thanks. Melissa Hortman, husband was Mark. Yeah. Thanks, Jesse. We need to get into a better place, a happier place. So I'm going to try to find a happier story to share tomorrow. That's what I'm going to do. Um, Tomorrow is my last day of full-time reporter work. Last day. Can you believe that? I will no longer be a full-time reporter at the end of the day tomorrow. I will be a full-time YouTuber and a part-time reporter. And I'm really looking forward to that. uh yes, yeah. You guys are, yeah, I'm gonna try to keep the happiness going. So anyway, so tomorrow is my last day. I've got a couple of good features that I need to submit, which I'm looking forward to. And then on Monday, it's going to be full-time YouTube. Now, I'm not sure what that's going to mean for the channel, if that means there are going to be more streams, longer streams, if we're going to kind of move the stream earlier than normal. I don't know, because I have always done it at 7:30 because I couldn't get to it before then with my full-time job. I would love your input on that. Um, I I don't know. I don't think I'm going to make any major changes to the channel over the short term. I'm just going to try to get into this whole rhythm of, all right, here we are. We're a full-time YouTuber, and hopefully that will mean better content. I think it'll probably be more content, and if it's more, I hope it's also better. Yeah. So, okay. Thanks, guys. I appreciate you taking the time with me tonight. I bid you adieu, and I will see you on the next one. Take care. Thank you very much for watching this video. If you liked what you saw, please consider subscribing. And if you have any questions or comments, please leave them below.